that the plaintiff's complaint is based on, relates to, or is in response to their exercise of the right of free speech. Here, because this entire lawsuit is based on speech about a good, product, or service in the marketplace, which is one of the enumerated statutory categories, all parties agree that my clients made this showing. The trial court did not, though. Now, the basis for that ruling is a mystery. It is unexplained, but the ruling was wrong, and clearly so. As importantly, on page 61 of their brief, the plaintiffs concede the trial court's error. To quote from their brief, quote, "Appellees have never disputed that the TPPA was triggered." That concession resolves the bulk of this appeal.
Does the statute require the court to go through that process of looking at that first prong anyway?
I think it does, at least based on some recent Tennessee Supreme Court jurisprudence, it does. But the evidence here is overwhelmingly one-sided. Their complaint, which is, includes a TCPA complaint that we disparage their goods, product, service in the market. I mean, this is what this case is about. It's the only thing in this case. So yes, I don't think you are bound necessarily categorically by the concession, but the concession is accurate, and this record is totally one-sided here. For these reasons, the trial court's order, which was issued only on this ground, should be reversed. Now, the parties do dispute the proper remedy under the circumstances, but this court has said what the proper remedy is 3 times this year in Garner versus Thompson, Goldberger versus Scott, and Cartwright versus Thompson. In all 3 of those cases, this court held that when the trial court errs at step 1 of the TPPA analysis, the remedy is to reverse the trial court's decision at step 1 and then remand with instructions to consider steps 2 and 3. To quote from Goldberger, which I believe, Judge Clement, you authored, here's what you wrote. "Because the trial court denied Mr. Scott's petition on the basis that Mr. Scott had not met the first step of the TPPA burden-shifting framework, we remand the case to the trial court for further proceedings, including consideration of whether plaintiffs met their prima facie burden, and if so, whether Mr. Scott nonetheless established a defense. Given that, we have asked this court to reverse at step 1 and remand for consideration as to steps 2 and 3. Also note that reversing and remanding has to be the remedy here. The reason is fairly simple. Adjudicating the remaining issues in this case requires the court to make evidentiary determinations, and this court does not do that in the first instance. So for those reasons, this court should reverse the trial court's order and remand to consider steps 2 and 3 of the TPPA analysis. The next issue in this appeal is this business about the plaintiffs attempting to introduce untimely evidence into the TPPA record. I was comforted to learn from the last case that trial courts are enforcing this. This trial court did not. Context here is this. 8 days before the TPPA hearing, my clients file an excerpt of Ms. Ward's deposition to support our claims here. In response, the night before hearing, the plaintiffs file a surreply that cited a bunch of different portions of that deposition which no one had ever filed. The TPPA plainly forbids this. Tennessee Code Annotated Section 20-17-104C says that evidence must be introduced no less than 5 days before the hearing. So during the hearing, I get up, I make sure to get my objection on the record, and I object to the court considering any evidence that was not timely submitted 5 days before hearing. During the hearing, plaintiffs do not respond to this objection. What they do instead, after the hearing is over, is go and file the full deposition transcript. This is clearly impermissible. TPPA says that at least 5 days before hearing, the evidence has to get in, and they go and try to file evidence after the hearing is over. Now, on appeal, the plaintiffs don't really even try to defend that misconduct. Instead, they argue that our complaint about it is waived because we didn't object a second time, file a motion to strike the evidence, come back to court, ask for another hearing, and then tell the court once again the TPPA has time requirements that forbid the plaintiffs from behaving this way. But this court has made...
If we were to agree with you on the first point, and that is to reverse and remand to consider step 2, what would prevent the trial court from considering this evidence since it will now be more than 5 days prior to the hearing?
Well, I don't think first of all, it wasn't in 5 days prior to the hearing. The hearing has already been had. The evidentiary record is closed. I certainly don't want to have to come back and do a third TPPA hearing with new briefing and more delay here. But our position on that is the hearing has happened. The evidentiary record regarding that hearing closed 5 days before it. We're not going down to reopen the evidence, reopen the record, and have a third TPPA hearing. That is not what the statute is supposed to do. I also just want to emphasize, as to their claim about repetitive objections being necessary here, the TPPA, as this court said in Andegam, exists to prevent abuse of this nature, not to enable it. If plaintiffs were allowed to get away with doing things the TPPA forbids, require defendants to constantly come back to court to express new objections about impropriety, this would have no value. Expeditious litigation, costless litigation, quick litigation, that is what the statute is designed to do. Doing what they did would undermine it. So in its opinion, we're asking this court to order that only evidence that was submitted 5 days before hearing or more can be considered when the court makes its final ruling. Turning to the last issue in this appeal, governing reassignment and remand. So just mentioned, courts are supposed to expediently resolve TPPA claims, and the statute presumes that they will. That's what this court held in Andegam Neurology versus Beavers. Tennessee Supreme Court has also held that protecting speakers from extended proceedings is the TPPA's central purpose. This case has not been resolved expediently. Instead, it has languished due to the trial court's inattentiveness and is now entering its third year. Even so, we are not even halfway to first base when it comes to adjudicating just this TPPA petition. This is unacceptable. I recognize the court is not likely to accept our argument that this case should be reassigned, something that happens very rarely, but I will ask this court to at least be forceful in its ruling, order the trial court to adjudicate the outstanding matters related to my client's TPPA petition within no more than 30 days of the mandate issuing, and make clear the evidentiary issues have to be adjudicated, the step 2 and the step 3 analysis have to be adjudicated promptly so that this case doesn't go 4 years, 5 years, 6 years just at the TPPA stage. For all of these reasons, this court should reverse. If the court has any questions, I'm happy to answer them.
Hearing none, thank you, Mr. Horwitz.
Thank you, Your Honor.
Good afternoon.
Good afternoon, Your Honors. Michael Johnson with K. Griffin Evans for the plaintiffs, appellees, Kedalo Construction, and its owner, Randy Wetzel. We are asking the court to affirm on alternative grounds, primarily for the reason that we just talked about, or that opposing counsel just talked about, which is this case has been going on for a long time. The trial court correctly denied the TPPA petition, albeit its order is somewhat vague on the grounds. And so we're asking the court to affirm the denial and remand for further proceedings.
Is the court required to give its grounds?
No, and we addressed this in our briefing. We do not believe that there is any legal basis, at least under the TPPA, for requiring a trial court to state its grounds. In a motion for summary judgment, we certainly have case law saying that that is the case. But in other types of motions like this, we're not aware of any case law requiring that.
What do we do with the fact that both parties agreed that the TPPA applied?
It wasn't even an issue below because we look at it the same way. It's a good or service in the marketplace. Didn't really have a good faith basis to argue that the TPA did not apply in the first place. And so I think that in our view, there are two options, and that is remand for a revised order. That is not ideal in our view because it just kicks the can down the road and we'll be up here on a second appeal. Or affirm on alternative grounds.
Well, you didn't reply to the other side's first prong, right?
That the TPPA
applied.
Correct, because we've never disputed that. We saw it the same way.
That's waived and really isn't anything to discuss here, right?
Right. I mean, we agree that the TPPA applies. We did not make the argument below that it did not because of that good or service.
So then shouldn't we just remand it for the rest of the prongs?
That's certainly an option. Our concern is that we're going to be, after a second appeal, 3 years down the road.
Well, yeah, but the court didn't rule on them.
So two possible ways to look at that in the alternative, I think.
Okay, give me the alternatives.
One is to, the the appellants recognize that there are circumstances in which the Court of Appeals can affirm on alternative grounds. And we would submit that this is such a situation where the court can look at this and say that, not for the reasons that necessarily the trial court said, but for other reasons, namely that the plaintiff made a prima facie case on each element of their claims, that the court correctly denied the petition. So I think that's one option. The second option is to read the order differently. And I think that there are two ways to read the trial court's order. So it's obviously, I know you've looked at it, it's a one-page order. The conclusion is, based upon a review of the motion and accompanying filings, to include the transcript of the aforementioned deposition. Not clear if that's the full transcript or partial. The court is of the opinion that the motion to dismiss is not well taken, the TPPA petition presumably, in that defendants have not met their burden. Now, the only other mention of burden in the order, obviously, is with respect to showing that the TPPA applies. The court cited the section of the TPPA that says the petitioner has the burden to show that the legal action against the petitioning party is based on, relates to, or is in response to that party's exercise of the right to free speech. The second part of the statute where the petitioner has a potential burden is with respect to defenses. And the petitioners in this case, the defendants, did assert several defenses in their TPPA petition. In addition to challenging whether plaintiffs have made a prima facie case, they asserted these defenses.
That's prong number 3, right?
Correct.
Nobody ever got to that one.
I think that's the only other way to read, the only other potential way to read this is that he's referring to burden. He states about the triggering of the TPPA, that section of the statute, does not address whether a prima facie case was made. It just says the petition is not well taken and that defendants have not met their burden. So that's the only other conceivable way I think it could be read, is that it's talking about the burden of the defendants to ultimately prove a defense. So I think it's that or affirming the alternative. Those are really the only options in our view. So now with respect to this evidentiary issue, so the deposition issue. So it's important to remember the timeline. It was just over a week before the hearing. Defendants file a partial transcript. No argument, just a notice of filing with a partial transcript. And then the Wednesday before the Friday hearing, at 11:59 p.m., they serve a reply brief with argument about that partial deposition transcript they had filed a week before. So we had 24 hours to look at that and turn around a response if we wanted to file anything ahead of the Friday hearing before the next day's midnight deadline. So we turned around a SIR reply. The clerk won't accept fax filings over a certain page number, so we couldn't fax file by the time we got everything ready to go. Clerk's office was closed. We couldn't fax file the deposition, so we filed it the next day with a notice of filing. The other thing that
was less than 5 days.
It was less than 5 days, and there's two things to talk about in that respect. One is that, well, actually three points. One is that the appellants, you heard them just say that evidence must be submitted 5 days prior to the statute, and that's just not what the statute says. Here's what the statute says. It says a response to the petition, including any opposing affidavits, must be filed no less than 5 days before the hearing. Undisputed, that happened. A response and affidavits. Now, the statute then says that what that says about other evidence is that the court may base its decision on supporting and opposing sworn affidavits stating admissible evidence and on other admissible evidence presented by the parties. Other admissible evidence, it does not contain any time frame for when that other admissible evidence may be.
Where is that?
That is in section 105D.
D. Okay.
And just like the court has discretion to hold a hearing and hear live testimony at the hearing, that would be introduced less than 5 days before the hearing. That would be introduced at the hearing. This kind of situation is no different. The statute is simply silent on when something like a deposition transcript, like we were hearing about a moment ago, subpoena documents, anything other than a response and affidavits the statute's silent on it. That's the first point. Now, the second point
You're
is
reading response very narrowly there.
correct, the response brief, correct.
Okay.
And the fact that other admissible evidence is included in 105D but not in 104C, where it talks about a response and affidavit. It doesn't say response affidavit and other admissible evidence. The second point is that the transcript was expressly filed pursuant to Tennessee Rule of Civil Procedure 32.014 and Rule of Evidence 106, both of which allow a litigant to present a full picture of evidence if only parts of it are introduced by the opposing party. So that is the second point, is that it was expressly filed pursuant to those rules because of the cherry-picked deposition transcript that was filed. Now, the third point is the only reason the deposition transcript matters, and the only reason anyone made any filings that week of the hearing was with respect to actual malice. And our position from day one is that this is a private plaintiffs, private defendant, small commercial construction contract. This is not a matter of public concern for the purpose of First Amendment jurisprudence. Our clients do not have to show actual malice. Our position is that they have. But the
You're
only
not arguing that TPPA doesn't apply because it's not a matter of public concern.
Correct. We're not making that argument.
Okay.
But it's not a matter of public concern for the purpose of First Amendment jurisprudence. And that means no actual malice is required. The only reason that deposition transcript was filed is it's the deposition of the defendant, Ms. Ward, and leave was granted to take that deposition because the plaintiffs or the defendants were arguing that the plaintiffs had to show actual malice. And so we said, okay, if they're going to take that position, we need a deposition. We were granted leave to do that, and that's the only reason that deposition transcript was in the record, and the only reason they filed that reply brief at 11:59 on Wednesday was to address actual malice.
And you had not addressed it before in your previous filing?
We had argued that actual malice was not required, and that based on her own self-serving declarations and the evidence she submitted, including admitting that she had actually done research on these statements, found no evidence, and published them anyway, that actual malice was satisfied if the court thought that, for whatever reason, that was required.
But you didn't go ahead and put in the deposition at that time?
Correct.
Okay.
Correct. So I think that although there's a few other issues addressed in briefing, I think we've kind of figured out that there's only a few narrow issues that we're considering today. But our clients respectfully request that the TPPA petition, the order be affirmed in the alternative. And if there are no other questions.
No.
Hearing none, thank you, Mr.
Thank you.
Johnson. Your rebuttal, Mr. Horowitz.
Thank you, Your Honors. I heard opposing counsel say that this order was vague. It is certainly incomplete as to its reasoning. There is none, but it is not vague as to its basis, right? It says the defendants have not met their burden, and it cites the first step of the TPPA statute. So it's very clear why this petition was denied. It was denied because the trial court determined that this was not a TPPA case. Everyone admits that that is wrong. This court should reverse it and remand. And even under this new reading of the order, which I don't recall in opposing counsel's brief, it means that the trial court would have skipped step 2 of the TPPA analysis as to whether or not they'd made a prima facie case for all their claims. It did not. And there are no evidentiary determinations made in this order, despite the pending objections below. So no, this court should not affirm on alternative grounds. It should not do the trial court legwork of making evidentiary rulings in the first instance, admitting evidence, striking some evidence. That's not what this court does. This court should remand just as it has 3 times this year under the same circumstances. As to this other admissible evidence business, this theory that you can, unconstrained by any time limit, introduce in a surreply new evidence whenever you want to is completely foreclosed by Nandagam Neurology. First TPPA case issued by this court happens to be my case where a misbehaving plaintiff did exactly the same thing here. Hearing was reset. Before the reset hearing, they tried to get in new evidence right before the hearing in violation of the TPPA's 5-day rule. Trial court said, I'm not considering it. On appeal, this court said, the trial court was absolutely right not to consider it. TPPA says 5 days. Ignoring that requirement would make these proceedings useless, right, which allows appropriate notice and orderly proceedings to occur. So the evidence was properly excluded, and it's not coming in. Exactly the same case here, a reset TPPA hearing, plaintiffs trying to sneak in evidence that I can't then respond to despite something like 35 or 40 different objections that I propounded during Ms. Ward's deposition, but then they introduce it after the hearing so that I can't get my objections adjudicated. This full transcript cannot come in. I've heard opposing counsel say they don't even really need it to support their prima facie case, so this court's order should simply exclude it and say that only evidence submitted 5 days before hearing is appropriate. I also note, nobody contests that there was a basis for attempting to admit the full deposition. If they had wanted to try to admit the full deposition in advance of hearing, that's perfectly fine. And then we'd, litigate our objections to the improperly formed questions during that deposition. That is not what they tried to do. They waited until the night before hearing and then filed it after the hearing occurred. This is not proper. This court should be very clear that evidence does not come in. It was not timely filed. Should reverse. It should remand. And this remand order should say all of the other issues in this case need to be adjudicated within 30 days.
All right, thank you, Mr. Horowitz and Mr. Johnson. We'll take your matter under advisement. Call the next case, please.
Jim Spangler on behalf of Fintlock Investors LLC versus Mac McClung.